All right, so in this, our second class on the Dormant Commerce Clause, we turn to more modern cases. So the cases we looked at last time, we looked at cases from the early half of the 20th century when the court was starting to develop the doctrine in a more rigorous fashion. And now we look at the cases that are governed by the more formal tests that the court sets out. So the first test I introduced you to yesterday, but we can see it in the, so today's reading is from the handout, which is actually just cases that were excerpted from an earlier edition of the same casebook that we have. So if you look at the first page under modern applications, the first page of the handout of today's handout, you see a test quoted there from that originates in this case called Pike versus Bruce Church. So this is the modern test, or this is a summary of the test that so we still have these two basic classifications, discriminatory laws, non-discriminatory laws. And the court tells us that a discriminatory law is virtually per se invalid. That means that there's a presumption against its validity, it's going to be subject to strict scrutiny, and the burden will be on the state to demonstrate that the law, one, advances a legitimate local purpose, and two, that that purpose cannot be adequately served by reasonable non-discriminatory alternatives. So once the court determines that the law is discriminatory, and it's that basic determination that we're going to be looking at with the second and third case that we read today. But assuming that you can decide that the law is discriminatory, what the court then scrutinizes is the reason given by the state for the passage of the law, and the court will really scrutinize that. It won't let the state get away with something just because the state says it. So the court will scrutinize the rationale behind the statute, and then the court will look to see whether or not there are other ways that the state could have achieved that goal, assuming that it was a legitimate goal in the first place. Other ways the state could have achieved that goal that wouldn't cause so much discrimination against interstate commerce. Now, if a law is non-discriminatory, then the opposite presumption rules. That is, the presumption is that the law is valid. And the burden here will be on the challenging party, the private party that wants to challenge the statute, or sometimes it will be another state challenging the statute, that the burden is going to be to show that the burden on interstate commerce is, quote, clearly excessive in relation to the putative local benefits. So this is a true balancing test. Then you look at the putative local benefits are the supposed benefits as asserted by the state. But because we are not in the strict scrutiny realm, the court is not going to interrogate those local benefits. So the court says the putative local benefits, that is, the benefits as asserted by the state without further interrogation from the court. So you weigh the putative local benefits, what the state says it gets out of the statute, and you weigh them against the burdens as shown by the challenging party on interstate commerce. But there's a presumption in favor of the validity of the state statute when it's non-discriminatory. I would urge you to keep track of the cases that we read. Maybe in some chart like this, it's going to be up to you as to which categories or how, you want to keep track of, how you want to organize it. But something like this might be a start. I think it might be worth further distinguishing cases, especially within the discriminatory section. But if you start a chart like this, you would have laws that have been upheld that are non-discriminatory, laws that have been invalidated, and so forth. So the next case that we're going to look at, we're going to see as an example of a non-discriminatory law that was upheld under the basic balancing test. Then we're going to turn to the Hunt case, which the court will tell us is a discriminatory law that the court will invalidate. Yesterday, we looked at the Illinois mudflaps case known as Bibb. That the court there said that was one of those rare non-discriminatory laws that the court had to invalidate because it failed the balancing test. And then tomorrow, we'll read a case, Maine versus Taylor, where the court upholds a discriminatory law under the strict scrutiny analysis. So do this for some of the other cases that we've read. So let's turn to the first case that's in the reading today, the Minnesota Cloverleaf Creamery case. And the heading in the chapter here is the modern benefit burden balancing test. So the main goal in looking at this case is to see how the court goes about applying that balancing test, that test where we have a non-discriminatory law and the state gets the presumption of constitutionality. So what does the statute do? And hopefully you'll notice as we go through these cases, the basic methodology will be the same. Identify the statute, identify the state rationale for the statute, look at how commerce is allegedly burdened, look at whether the benefits accrue to the state, and then do the balancing. All right, so the statute. What is the statute here? We see that the statute is a Minnesota statute that bans the sale of essentially non-recyclable containers, plastic containers, for dairy products. All right. So Minnesota is trying to get to the paperboard milk cartons instead of the non-recyclable plastic bottles. And the justification here, as you can see in the section, the purpose part of the statute that's quoted there, is to reduce landfill waste, conserve natural resources. So this is an environmentally motivated statute. Is the statute discriminatory or not? In the next two cases, we'll look at some factors that the court sets out for how you determine whether a statute is discriminatory. What does the court say here? Well, the court finds that the statute is not discriminatory. Why is it not discriminatory? Because it applies to everyone here. So the prohibition is on selling milk or other dairy products in plastic non-returnable containers, and instead they should be sold in paperboard cartons. But that's going to apply to everyone across the board, not just out-of-staters. In-staters must do that as well. One objection is that Minnesota has a paperboard industry. In other words, there's a local business that might benefit from this shift, because all of a sudden, if people can't use plastic containers anymore, there's going to be a need for paperboard product, and it just so happens that some of those paperboard companies are located there in Minnesota. But the court says that that is not in and of itself discriminatory, because although it might be true that initially some local Minnesota businesses might benefit by having increased business, paperboard companies can pop up in any state. And there's no reason to suspect that out-of-state paperboard companies might not get the business that would be generated by companies no longer being able to use plastic containers. So the conclusion is that the statute is not discriminatory. So because the statute is non-discriminatory, the court says, and this is on page 337 of the handout, the statute does not effect simple protectionism, so this is not Minnesota simply wanting to protect its in-state industries from out-of-state competition. Instead, it regulates even-handedly. So therefore, we apply the test for non-discriminatory laws, which in the third paragraph under Part 3, the court says, since the statute does not discriminate, it's controlled by the question whether the incidental burden imposed on interstate commerce is clearly excessive in relation to the putative local benefits. So the next paragraph, the court says the burden imposed is relatively minor. So why is the burden minor? Well, companies would only have to engage in a slight modification, if any, the court says, to current milk packaging practices, because most companies already produce a number of different packaging. There isn't, the court is finding that there isn't any company that solely uses plastic bottles and will have to completely shift. So only slight modifications to the existing industry. As I already mentioned in explaining why it wasn't discriminatory, the plastics industry might lose and pulpwood industries might gain, but those losses and gains are not determined by state location. Right. And then the court says, note that there's a presence of in-state plaintiffs here. So the statute then is harming in-state businesses as well as out-of-state businesses. So that is another indication that, one, it's not discriminatory, and two, the burden is minor in the sense that the state is able to receive feedback from its own voters and make determinations that wouldn't unduly harm any particular business in the overall industry here. Remember, one of the concerns, going back to the set of rationales or justifications for the whole concept of the Dormant Commerce Clause, one of the concerns is that you might have state laws that primarily affect out-of-staters. And out-of-staters, of course, have no say over how state laws get made. But when you have an in-state entity that is affected by a statute, there's far less concern for the Dormant Commerce Clause to operate, because the ordinary political process can take care of any law that imposes too much of a burden on any particular industry. And then, so this is a balancing test. We balance the burdens on interstate commerce, the incidental burdens on interstate commerce, against the putative local benefits. And the court says here that the benefits are pretty substantial. We find the burden is not clearly excessive in light of the substantial state interest in promoting conservation of energy and other natural resources. So the court here has an easy time in upholding this statute under this balancing test that favors the statute because it's non-discriminatory. So how do we know when a statute is discriminatory then? So there are some factors that the court has set out that help us with that. Again, this is a factor-based test, so you're always going to have to make a good argument as to why a statute is or isn't discriminatory. So one factor that indicates discrimination is that all out-of-staters are virtually excluded from a particular state market. All out-of-staters are virtually excluded from a particular state market. Think back to the cases that we looked at yesterday, the milk cases, where the court says that there were virtual exclusions of all out-of-staters selling milk in New York or in Madison, Wisconsin. Another factor, costs are imposed on out-of-staters that in-state residents do not bear. And 3, evidence exists of a protectionist purpose. So if it's not obvious just from the effect of the statute, there might be some purpose that could be discovered through looking at the legislative history as to why the statute was passed. So this is for discovering discriminatory purpose or effect. So these situations will arise when there's no discrimination on the face of the statute. So as I mentioned before, when I was showing you that 4x4 chart, and I suggested that you might want to make some subdivisions to it, in particular under the discriminatory row, because a statute can be discriminatory, the court tells us, on its face. So the wording of the statute says you can't sell milk here if it comes from out of state. Right? That would be discriminatory on its face. But the court says a statute might also be discriminatory in purpose or effect. And for purposes of the strict scrutiny analysis, it doesn't matter whether it's discriminatory on its face or in purpose or effect. Both types of discriminatory statutes will be subject to this strict scrutiny analysis. So these are the factors then that indicate discrimination when that discrimination is not obvious on the face of the statute. So what cases have been facially neutral yet discriminatory? And we're going to see an example of that in the next case, the Hunt case. The other two cases that we read, the one we just finished and then the last one we'll look at, they're facially neutral, but the court finds that they're not discriminatory. All right, so let's look at the Hunt case. So in this case, we have a North Carolina statute that prohibits the shipment into the state of closed apple containers that have any mark on them other than the U.S. grade. So they could be unmarked, but if they have a mark on them, they have to be the U.S. grade. So in effect, this bans any state grading systems on the crate of the apples. So why does North Carolina pass this statute? Well, it says the putative justifications here are to protect citizens from fraud and deception in the marketing of apples. So, because there are a number of different states that have different grading systems, and those grading systems vary in quality from state to state, North Carolina says we want to prevent consumer confusion because they might buy a grade A apple at one time, and that happened to be from a particular state that didn't have great apples, and then they buy it at another time, and it turns out to be just completely different quality apples, although they're both labeled the same grade. So this is a foodstuffs consumer marketing type statute that you would expect to ordinarily fall within the police powers of a state to pass. So what do we know? So we need to know something about the market. And usually you'll notice that the court gives us facts about the market. So remember when we were looking at the Arizona case, we had facts about the way that trains usually operate. We have facts to know how semi trucks usually run with respect to their mud flaps. So we need to know how apples are usually marketed in order to determine whether there's discrimination going on here. So we learned that Washington is the nation's largest apple producer, and that Washington has a state grading system, and that the state legislature is heavily involved in regulating the Washington state grading system. And this grading system is actually superior to most other grading systems. And remember, the statute said that the only grade that could be on the crate of apples is the U.S. grade, the national standard, the USDA grade. But Washington's grades are superior to all other grading systems. So, for example, let's say a Washington grade B apple might be even better than what would get qualified as a U.S. grade A apple. And so then you can imagine then that the grade A apples in Washington obviously would be grade A apples under the U.S. But let's say that everything that would fall into the U.S. grade A apple, Washington would have 3 subdivisions that represented distinctions, right? So let's say that let's say that the U.S. only uses A, B, and C grades, and Washington has A+++ apples, A++ apples, and A+ apples. And those would all have to be lumped in now just to the plain old A under the U.S. grading system. And we're also told that, so how would the North Carolina statute affect the workings of the apple market nationwide? And the court tells us that on page 357, that the statute would have a potentially nationwide significance. Why is this? Well, so unlike what the court just said about the Minnesota milk container statute, here the apple industry in the various states would have to change their labeling systems. I'm sorry, I said here states would have to change, but really what I meant there is industries. The apple industries in various states would have to change their labeling systems because the labels are already printed with what's ordinarily on those labels for every state. So they don't have unique North Carolina labels. But if Washington wanted to continue to sell in North Carolina, they would have to do one of several things. They would either have to create separate North Carolina labels, but that would then mean completely reorganizing how they pack their product, because at the moment they pack all of their apples into crates and then they don't know which crate is going to go to which state, so they would have to start segregating them. Or the alternative would be Washington apple producers could simply disregard the state grading system and use the U.S. grading system, but that would then mean that the practical effect of the North Carolina law was to change the way that apple growers do business throughout the whole U.S. And so then it seems like one single state, North Carolina, is dictating how a nationwide market should work. So, as the court calls it, potentially nationwide significance to this statute. So that in and of itself might cause some concern then if we were to undertake a balancing test. So Why is this statute facially neutral? It doesn't look discriminatory on its face because the same thing could be said of this statute that was said of the Minnesota milk carton statute, that everyone, not just out-of-staters, have to comply with this statute, right? North Carolina apple producers would have to comply with this statute as well as Washington apple producers. So on its face, it appears to be neutral. But the burdens here on interstate commerce appear to be, as in the court's words, potentially significant. But the court tells us that there's another problem. So the court doesn't even have to engage in that balancing test because the court tells us that this statute over on page 359, the challenge statute has the practical effect of not only burdening interstate sales of Washington apples, but also discriminating against them, right? So the court seemed to be hinting that the burden would be significant here if it were doing the balancing test. But because the statute is also discriminatory, then it's going to get the even stricter heightened scrutiny test. So how does the court determine that a statute is discriminatory when it seemingly, on its face, applies to all the industry in all the states? And the court points out three factors here that show discrimination in this particular statute. So, and I have these circled here on page 359. So what are the factors that indicate discrimination with this particular statute? Well, the first, the court tells us, is that there are costs that Washington growers bear that North Carolina growers do not. Right? So because Washington apple growers are so invested in their grading system, their labels are naturally already made, and the North Carolina apple growers would not have to change anything. So there is significant cost then that all other states that have grading systems would have to bear that North Carolina growers would not. Second, the court tells us the record demonstrates that the Washington apple grading system has gained nationwide acceptance in the apple trade. So here, the one thing that Washington apple growers depend on for sales is taken away by the North Carolina statute. And then the third thing the court tells us is that the statute has a leveling effect, which insidiously operates to the advantage of local producers. Right? The court says that the statute, well, that last part I have underlined, the statute downgrades, right? It downgrades these superior apples. And the court says that the downgrading is the very sort of protection against competing out-of-state products that the Commerce Clause was designed to prohibit. So how is that the case? So again, assume that Washington apples, that there are three different classes that Washington, let's say that Washington would put an A triple plus on some apples, the very best apples, an A double plus on others, an A plus on others, and then a regular A on some. So that would be four types of apples that Washington growers would sell in the market. And obviously the A triple plus ones would be the highest priced, and of the A, the lowest of those four groups. But if Washington apple growers were forced to use the U.S. system, they would have to label all of them A if they wanted to sell them in North Carolina. And the court calls that effectively downgrading it, because now there's no way to distinguish the A triple plus apple from the ordinary A apple. And the court says that is not only downgrading, but at the top of page 360, the court says that the statute will have the effect of an embargo against those apples in the superior grade, as Washington dealers withhold them from the North Carolina market. So why is the effect of the statute a practical embargo? It's almost as if North Carolina said in the statute, don't bother sending A++, and A triple plus apples to North Carolina. It's almost as though the statute said, keep your superior apples out of North Carolina. Well, because the dealers, the Washington apple dealers, if they're only going to get a return on their apples that they would get on A-grade apples, if they're going to get the same return on A triple plus apples that they would on A-grade apples, then why bother sending the superior apples to North Carolina if it's not going to pay off? They might as well sell those best apples in the states where they can actually get the value for those apples. So the court says here this is tantamount to an embargo against those superior grade apples. So 3 factors that show that the statute in effect targets Washington apples and has the effect as though the state of North Carolina had said Washington apples are not permitted to be sold here. At least Washington apples that would compete and perhaps do better in the market than our own North Carolina apples cannot be sold here. So before we get to that slide, I want to show you this paragraph, this first full paragraph on page 360. Now, the court says that it's enough to call this statute discriminatory in effect because of these 3 factors. But the court says that there's also some evidence that the purpose or the motivation behind the statute was discriminatory. Now, I said at the outset that the putative benefit, the supposed benefit that North Carolina says is attached to the statute is this consumer protection anti-fraud statute. But the court says there's also evidence that the actual purpose was protectionist, was to protect in-state apple growers from competition. And you can see that the quotation there of some exchanges when it was asked, the North Carolina Agriculture Commissioner was asked about exemptions from the statute. He said, quote, he wanted to have the sentiment of our apple producers since they were mainly responsible for this legislation being passed. So that seems to be a concession that the in-state apple producers were behind this statute and that the statute really does look like the whole point of it was to protect them from competition, not really to protect the public from fraud. But the court says that's not necessary because if the court, understand why the court's hesitant to draw that conclusion, because the court would essentially be concluding 2 things. One, that North Carolina had a bad unconstitutional motivation, and 2, that North Carolina lied about its motivation. And so the court says we don't have to say that, although there's apparently evidence of that, but we don't have to say that to make the determination that the statute is discriminatory because it's discriminatory in effect. So once the statute is discriminatory in effect, we know that the burden shifts to the state and we see this quoted in the next paragraph. When discrimination against commerce of the type we have found is demonstrated, the burden falls on the state to justify it, both in terms of the local benefits flowing from the statute, and 2, the unavailability of non-discriminatory alternatives adequate to preserve the local interests at stake. So we have to ask these questions then. Do the local benefits outweigh the interstate burdens? And 2, are there less discriminatory means to achieve the asserted state interests? So looking at the first part of this 2-part test in the next paragraph, the court says that there are few local benefits that actually flow from the law. Right? So remember, the way the statute worked is it prohibited closed containers of apples that had a grade on them other than the USDA grade. The court says, but if the real concern was to protect consumers, it's an odd way to do it because consumers would almost never see that closed container. When you go to the grocery store, the apples are already unpacked for you and placed on a table or on some sort of display case in the grocery store. You don't see the apples in the crate in which they were shipped. So that's an odd way to protect consumers, right? And you can see it directs its primary efforts not at the consuming public, but at the apple wholesalers, who are the principal purchasers of the closed containers. And then 2, are there less discriminatory means? Well, the court says yes, and then it gives a couple of examples of ways that North Carolina could achieve true consumer protection, the true consumer protection goals. They could mandate that the labels have both the state and the USDA grade. That way, you have a benchmark for comparison. So the court says that there are other ways that North Carolina could achieve this supposed justification, but it's also clear that the court really doubts that that was the original justification for the statute in the first place. All right, so there we have two different cases that where the state statute is neutral on its face, that is, doesn't discriminate on the face of the statute. And in the first case, the milk container case, the court finds that that is in fact a non-discriminatory statute, and the benefits of the statute outweigh the burdens on interstate commerce. But of course, there's a presumption in favor of that outcome. Here, the court finds that although it's neutral on its face, it's discriminatory in practical effect, discriminatory in particular against Washington state apples in practical effect, and therefore it must be subjected to the heightened standard of review. And under that heightened standard of review, the burden is on the state to make these two showings here, and the state can't make these two showings. Right? And notice the difference. Remember, there was the non-discriminatory statute also asks about weighing benefits and burdens. But look again back at the Minnesota case, where the court accepts the state's justifications. There was discussion, I'll just call your attention back to page 336. You can see the paragraph under part 1 of the opinion that starts, the act was introduced with the support of. You notice there's an argument by proponents, an argument by opponents, and there was a good debate over whether this Minnesota statute would actually have any effect on the environmental goals that Minnesota says motivated this statute. But when it's a non-discriminatory statute and you're not engaging in heightened scrutiny, the court is not going to entertain the losing arguments in that debate. But here, where the burden is now on the state, the court will look at the arguments that were made over the statute, and the court is going to have to find them convincing, because when the statute's discriminatory and practical effect, there's already a suspicion that the state's justifications were not the real justifications.
Do you like apples?
Yeah.
Well, I got a number. How do you like them apples?
All right, and the last statute, or the last case rather, Exxon versus Maryland. Why does this statute, why does the court conclude that this statute is not discriminatory in effect? So what does the statute do? The statute says that any producer or refiner of petroleum products may not operate any retail service station within the state of Maryland. So if you are a producer or refiner of petroleum products, maybe like Exxon, you cannot operate a local gas station within the state of Maryland. So the statute would appear to prefer independent gas stations that are not themselves owned by refiners or producers of petroleum products. And what was the rationale? Well, this is in the wake of the petroleum shortage of the early 70s. And the thought was that these refiners and producers were giving preferential treatment to their own gas stations and others, and as a result, the entire public was not benefited by that arrangement. And so Maryland wants to eliminate all such stations that might get favorable treatment should there be another petroleum shortage in the future. So why is the statute not facially discriminatory? Over on page 362 under Part 3 of the opinion, you can see the two reasons given here. So the court says, first, there's no in-state petroleum producers that would benefit from the statute. So there isn't an Exxon that is somehow benefited from this statute that is within the state of Maryland. Right. So plainly, the Maryland statute does not discriminate against interstate goods, nor does it favor local producers and refiners, because there aren't any in the state that would benefit from the law. So the way that we looked at the previous case, the Apple case, we saw that there was an in-state Apple industry that would benefit from the statute. Here, and then if we look back to the milk cases that we read, there were in-state dairy industries that would benefit from those statutes. But here, there's no in-state Exxon equivalent that would benefit from the statute, so it doesn't look like Maryland is trying to protect in any particular in-state industry. What about the argument, though, that it might be protecting local independent gas station owners? Well, the court says that in-state independent retailers are not protected from out-of-state competition. And this is an important point to understand. So one argument might be, although there's no in-state Exxon equivalent to benefit from the statute, what about the mom and pop gas station that would seem to benefit? That would be an in-state mom and pop gas station, and so that would seem to be benefiting against an Exxon-owned gas station. But the court's point is that, sort of like the point made in the Minnesota case, that yes, there might be some in-state independent gas stations that will benefit, but they're not protected from competition by out-of-state independent retailers. Maybe there is some entity known as Mom and Pop Gas Station Inc., and they own gas stations in 30 different states. There's no reason that they couldn't come into Maryland, so long as they are not themselves a producer or a refiner of petroleum. So yes, some local independent gas stations might benefit, but there's no reason to think that they wouldn't face competition from out-of-state independent gas stations as well. So therefore, the court finds that this is not Hunt, this is not Dean Milk. The fact that the burden of state regulation falls on some interstate companies does not, by itself, establish a claim of discrimination. And when you look on page 363, you can see there the argument that the court is rejecting, which is Exxon's argument, goes to the wisdom of the law, not the burden on interstate commerce. And again, just like I showed you with the first page of the Minnesota case, that there might well be dispute about these laws. There is always going to be someone that says the law is not going to be effective, it's not going to accomplish what the state thinks it's going to accomplish. But so long as the court doesn't find discrimination, the court is not going to involve itself in that policy debate. It's only when the burden shifts to the state, because the statute has some sort of discriminatory purpose or effect, it's only when that occurs that the court will then start to examine these benefits and burdens for itself. Okay, so again, the important point here is to three things. Appreciate how the balancing test works when we don't have a discriminatory statute. Benefit of the doubt goes to the state. Understand how this heightened scrutiny test works when the statute is discriminatory. So in Hunt, just like we saw in the milk cases, the court will second guess the determinations made by the state and will suggest alternative, less discriminatory methods that the court could use to accomplish its stated goals. And then the other main thing here is understand how to identify discrimination when you see it, even if it's not on the face of the statute. In practical effect or on purpose, the statute might be discriminatory, so you'll need to be able to essentially apply those three tests. The test for non-discriminatory law, the balancing test, the test for a discriminatory law, and then the test for discrimination in and of itself. All right.